This is Tommy Sheridan on Tommy Talks.
Welcome to this edition of Tommy Talks, the Sputnik show that tries to get to the bottom of what's going on in Scottish politics and reveals the real struggles that are developing under the surface. I have for many a year claimed that the independence campaign is primarily a grassroots campaign made up of ordinary men and women whose only aim is to secure Scotland's freedom and the right to stand up as an independent nation. And perhaps one of the finest indications of the grassroots nature of that campaign is the guest I'm going to be chatting with today, a man who I have cast as David against Goliath. Goliath being the British government and the court system, because this David has decided to raise a court action in Scotland's highest court to determine whether the Scottish Parliament does have the right to hold a legal referendum on independence without Westminster's permission. And that man is Martin James Keatings. Martin, welcome to our podcast today. Are you in good spirits and health, brother?
Yep, everything seems to be going all right for once at this end.
I have said, Martin, that you are the David in this David Goliath story, because the truth is you have raised an action in the High Court of Scotland, and the people who you've raised the action against is effectively the Scottish government, but also the British establishment and the British government, because you are trying to establish whether or not Scotland, under the Scottish Parliament Act 1998, actually has the power to hold a legal referendum. And you had to raise several £1,000s to actually get this into court in the first place. Describe to us, what's the motivation behind this people's action on Section 30?
Well, in terms of motivation, there's actually, it's multifaceted. After the first rejection of a Section 30 order from Westminster, I made a pledge that if it happened again, then action would have to be taken. And that would be in the form of trying to establish that we didn't need the consent of Westminster in the first place to actually go ahead with it. And a lot of people at that time kind of shrugged it off of as we'll see what happens. Of course, Boris Johnson was then elected to become Prime Minister of the UK under the Tories. And immediately there was another rejection. And that brought us to December 2019. So between December 2019, February 2020, we had a legal opinion commissioned with Aidan O'Neill QC on exactly whether or not it would be lawful for the Scottish Parliament to legislate for a second referendum without the consent of Westminster and without modifying the Scotland Act. He came back to me and says there are very good arguments that under the law at the moment as it stands, there are good arguments that Scotland could hold that referendum. And on that basis, it then went to pre-litigation correspondence to the UK government to put a position to them. They quite predictably came back and said, no, we believe that they don't have the right. A dispute therein existed, and the case pretty much started from there. But we've tried from the start to make it completely about the Scottish electorate. It can't be diminished in the fact that this is, at its core, it started off with an original 6,000 funders, and that's since expanded up to over 10,000. And that's ordinary members of the electorate asserting their right to vote on the constitutional question themselves. And politicians have kind of been sitting on the sidelines, So it is by its very nature an exercise of the democratic process from the grassroots up, rather than from, the political elite, shall we say, down the way.
That's a wonderful thing, isn't it, Martin? Because you mentioned the original 6,000 who were involved in raising the money to get the legal opinion and to get this whole court case going. Because, as you know, in Scotland, the courts are not for the ordinary pleb, as you've often referred to yourself as. They're for the rich men, aren't they? Rich men and women. But you've raised this action with the support of over 10,000 others. But the the court case, they've tried to argue, the Lord Advocate and I believe the British Crown are taking up these arguments now, that you don't have any standing. How dare you raise this action in the High Court in Scotland? Is that one of the things that's angered you as well, that they say that you shouldn't be doing this? It's not your place to raise this question?
Well, and to be perfectly honest with you, on my part, for myself, I'm not so much angry for myself. What I'm angry about is that in the very first paragraph of the summons, it states quite categorically that this action is raised on behalf of 10,000 ordinary members of the electorate. So the exact statement that was made was, it's not for the pursuer to stand in the shoes of parliamentarians, wasn't just directed at me, it was directed at 10,000 ordinary members of the electorate simply seeking an answer to a legal question with respect to their own constitutional future. And I just thought to myself, the hubris of that statement to be contained within legal documents is just completely inappropriate. What makes the situation worse, though, is it is not just a statement in passing in an actual response to our action. It is literally the entire defence of the UK government. They haven't advanced any opinion whatsoever against our assertion that the Scottish Parliament could legislate for a second referendum now. Instead, they've solely concentrated in trying to delay the action and trying to kick the action out and trying to stall it and trying to undermine it. It's all been about the technicalities. They haven't actually argued against the argument we put forward that the Scottish Parliament can legislate for a second referendum now.
Well, that's the fundamental truth, Martin, that I actually love. I love the fact that you are a grassroots independence supporter from Dunfermline. You're involved. You organised the Forward as One campaign. You have organised yearly annual marches for independence through Dunfermline. You've done a fantastic job. And you, as a citizen, are so angry that Boris Johnson and before him Theresa May decided to turn round and tell the Scottish people, we are not giving you permission to consult on whether you have independence or not. We're refusing that permission. So what you then said is, you said, no, wait a wee minute. We, under the Scotland Act, we have the right to hold a referendum on independence, and I'm going to court to prove that. And instead of taking up that argument, Martin, what they've tried to do is they've tried to undermine you at every turn. They've tried to say that you don't have the right to bring this to Parliament. And it appears to me that this case is going to be about them trying to beat you on a technical knockout rather than on the substance of the argument.
Pretty much, yeah. It's all about the technicalities and, or as I say, all flash, no bang. It's the absolute hubris of the UK government, because when I was born in this country, I was born with the sovereign right of a standard ordinary person in this country. And as we all know, the people of Scotland are sovereign, not Parliament. Unlike, the English equivalent, where in England it's Parliament that's sovereign, not the actual people. So from the beginning, it's been a case of reading some of especially the responses from UK Prime Ministers to the elected First Minister of this country. If you take Theresa May, for instance, Theresa May's response to a request for a Section 30 order from the First Minister worked out as, now is not the time. But she didn't respond in writing. What she did is she went on TV the next day and said it, now is not the time. There was no official response. And then you have Boris Johnson responds to a request from a Section 30 order from the elected First Minister of Scotland. And what does he do? He responds containing this perpetuated lie that they've consistently tried to push, the once in a generation, which always omits the word opportunity at the end, which the literal definition of opportunity is, of course, a time and set of circumstances that make something possible. So if the circumstances change, then it becomes possible again. And you just sort of sit there and think, wait a minute, Nicola Sturgeon was specifically elected to represent the people of Scotland. The people of Scotland are sovereign. It's not the fiefdom of politicians to tell us when and where or whether we can hold a referendum on our own constitutional future. That's not the fiefdom of politicians. That's the fiefdom of the general electorate, because we're sovereign in Scotland. So, the general arrogance And that's the exact word I'm going to use, arrogance of representatives of the British government when it comes to this action has just been downright snippy.
Martin, the problem I have with these people is they don't treat us with the respect that they expect us to treat them with. As you say all the time, we are a sovereign people. We are supposed to be the ones who instruct politicians, not politicians instructing us. And yet when I look at this case, which I believe is going to be held over 2 days on January 21st and 22nd, is that correct?
Yeah, it'll be 21st and 22nd of January, although we have a hearing on the 12th just coming up, which is a procedural hearing. But the main substantive hearing is the 21st and the 22nd.
The point that I'm sure Aidan O'Neill QC will be making there is that the actual establishment of the Scottish Parliament as a statutory body means it is subject to laws. Of course it's subject to laws, and there are constraints in its actions as there are constraints in any statutory body that's established. However, this issue of whether we can organise a referendum has never been tested, and during the debate on the Scottish Parliament being established way back in 1998, it was clear in the Parliament that it was an issue that was not decided. There was debates between Donald Dewar and others in the Westminster Parliament over the question of whether a constitutional referendum could ever be organised by the Scottish Parliament, and it was not established in black and white. So this has never been tested. This must be tested, because the point you make in your arguments, fantastic 33 pages worth of arguments that you've submitted for the case. The point you make is the Scottish people deserve to know before the May elections whether or not the Scottish Parliament is able to hold a legal referendum, because the SNP says that if we vote for them and give them the power, they will call such a referendum. So we need to know whether they are legally able to do that, don't we?
Well, yeah, that's right. Under the Scotland Act, which for those of your listeners that don't actually know what the Scotland Act is, it's effectively the act that was passed at Westminster that brought the Scottish Parliament back into being. And it's effectively the rule book on how devolution is structured. Contained within that, we hear the word Section 30 all the time with relation to permission from Westminster, but the next section in that act is actually what's called Section 31. And Section 31, in simple terms, states that any person that puts forward a bill to the Scottish Parliament has to make a declaration that that bill is within the competency of the Scottish Parliament to pass, which seems very simple. At the same time as well, the presiding officer of the Scottish Parliament also has to make a similar declaration. So what you have is a situation whereby, because the question over whether or not the Scottish Parliament can actually hold a referendum or not without the consent of Westminster, we actually have no way of knowing whether the bill that the Scottish National Party are proposing to put forward would be within the competency of the Scottish Parliament. So that means that the First Minister, when she puts that bill forward, or whether it's Swinney on her behalf, or Mike Russell, or any of the other MSPs, they're not going to be able to truthfully make a declaration that is within the competency, because this subject has never been tested. That is literally the point of our action. So we argue quite categorically it's the right of the Scottish people to understand exactly what they're voting for. Because if the Scottish Parliament put forward this bill and it transpires that they didn't have the competency to put it through, then we would be voting on a mandate which the Scottish National Party didn't know whether or not they were actually going to be able to implement. So this question has to be answered before we get to the Scottish elections. And the action itself, if we get a positive result, will actually mean that any bill that the Scottish National Party itself want to put forward will be legally competent completely, without argument. There'll be no way for the UK government to challenge it, because the court will have already said it's competent.
Martin, that's a fantastic point, because the issue that the British government, and I believe the Lord Advocate in Scotland, who's a member of the Scottish government, so why he said this is beyond me, but they have tried to argue that the action is premature, that you shouldn't be asking this question just now because there is no bill on the table to say that there's going to be a referendum. But the point you're making is, well, it's chicken and egg, isn't it? How can you have a bill on the table if you don't know whether the Scottish Parliament is legally competent to hold a referendum without Westminster sanctioning that? And you and I have to argue that there surely has got to be a basic law question here about human rights. I mean, the right of a nation to consult its own citizens on whether it wants to stay in a voluntary union or not cannot be in the gift of the person who controls that union. I mean, it's a bit like a jailer and a prisoner here. I mean, the jailer should not be the only one who decides whether the prisoner gets out of prison. The prisoner has to have some rights here, and we surely have the right to consult the Scottish people, because the Scottish people can say no, and if they say no, then that's it. But the Scottish people need to have the ability to say no, and the Scottish Parliament has to have the right to consult the Scottish people. And that's what you're trying to establish, isn't it?
Exactly, yeah. I mean, I liken it to the protester having to go to the person they wish to protest in order to seek their permission to actually protest them. I mean, the right to self-determination under Article 1 of the UN Covenant on Political and Civil Rights is so important that they made it the very first paragraph in that document. It's enshrined in the UN Charter. It's enshrined in the rights under the European Convention on Human Rights. Self-determination is something that, is so important. It's been enshrined in a multitude of documents throughout our history. Self-determination has to be initiated by the person that wants to, have that vote on the constitutional question, wants to exercise that right. It's not the fiefdom, and it is not the right of a person with a vested interest in the status quo to dictate what rights, with regards to self-determination, a person can and cannot exercise. That's completely antithetical to the whole idea of self-determination. That's not self-determination. That would be, I don't even think there is a term for that. I think we can just put it under vested interest.
Exactly.
It's like turkeys trying to vote for Christmas. It doesn't work. So.
It certainly wouldn't be consistent with any of our ordinary understandings of human rights, Martin. Martin, James Keatings, it's been fantastic to listen to your arguments today. I hope that you are successful in this court action, which will be heard over the 2 days of 21st, 22nd of January. I think that you are a tribune on behalf of the grassroots independence movement, but also on behalf of the ordinary people of Scotland. We hope that you are successful. We believe you should be successful, but I do have to say that the courts are not always paragons of justice. Usually they lean very heavily towards vested interests and the powerful, but sometimes we can have a wee chink of light escaping from those courtrooms, and hopefully in this case we will get that wee chink of light, and we will get the green light for the go-ahead for the Scottish independence referendum. Martin James Keetings, thank you for joining us today on Tommy Talks. Join us again next week.